What started as a business meeting is now a federal kidnapping case. People traveled to Dallas expecting to negotiate a recording contract. Hours later, federal prosecutors were calling it kidnapping, robbery, and a coordinated criminal event. So the question is not just what happened. The question is how the government turns a business dispute into a federal prosecution. Welcome to Inside Federal Defense. Here, we break down real federal cases, real charges, and real defense strategy using publicly available records. We focus on what the government claims, what it must prove, and where the defense begins. According to federal prosecutors, 9 individuals have been charged in connection with an alleged kidnapping and robbery at a Dallas music studio.
I'm Ryan Rabel. I'm the U.S. Attorney for the Northern District of Texas. Thank you for coming. This week, 9 individuals, including well-known musical artists, kidnapped and robbed at gunpoint numerous victims at a music studio in Dallas, Texas.
According to the complaint, firearms were allegedly produced, control was established, the individuals inside were not free to leave. The government further alleges that one individual was forced to sign contractual documents at gunpoint, and that multiple victims were robbed of jewelry, cash, and other personal property, and that at least one victim was physically assaulted, choked to the point of nearly losing consciousness. If those allegations are proven, this is no longer a contract dispute. It becomes a federal kidnapping case. The government has now obtained an indictment. A grand jury has formally approved 5 separate charges, which include Count 1, conspiracy to commit kidnapping. Count 2, kidnapping, aiding, and abetting. Count 3, conspiracy to commit extortion by force, violence, and fear. Count 4, extortion by force, violence, and fear, aiding and abetting. Count 5, interstate transport of stolen goods, aiding and abetting. And we're going to walk through each of these one by one. Count 1 is conspiracy to commit kidnapping, and that charge is significant because under federal law, the government does not have to prove that a kidnapping was completed. Instead, they must prove that 2 or more people agreed to commit a kidnapping, and that at least one person took a step in furtherance of that agreement. That step, often called an overt act, can be something small. It does not have to be the kidnapping itself, so the focus here is not just on what happened, but whether there was an agreement and whether actions were taken to carry it out. And once a conspiracy is alleged, the case changes, because in some situations, the actions of one person may be attributed to others involved in that agreement. That is why multi-defendant federal cases become complex very quickly, and why this count alone carries serious exposure. Count 2 is kidnapping. And unlike conspiracy, this charge focuses on the alleged conduct itself. Under federal law, the government must prove that a person was unlawfully seized, confined, or held against their will, that force, threats, or coercion were used, and that federal jurisdiction applies, such as interstate activity or the use of a facility of interstate commerce. But this count also includes aiding and abetting, which means the government does not have to prove that every defendant personally carried out the kidnapping. Instead, they can argue that a person knowingly participated and intentionally helped bring it about. So the focus here becomes twofold: what actually happened and who, if anyone, knowingly helped make it happen. Count 3 is conspiracy to commit extortion by force, violence, and fear. And like Count 1, this is a conspiracy charge, which means the government does not have to prove that extortion was successfully completed. Instead, they must prove that two or more people agreed to obtain property through force, threats, or fear, and that at least one person took a step in furtherance of that agreement. But the underlying theory here is different. This is not about restraint. This is about coercion. Under federal law, extortion involves obtaining property with a person's consent, but consent that is induced by force, violence, or fear. So the question becomes, was there an agreement to obtain property through coercion, and were actions taken to carry that out? Count 4 is extortion by force, violence, and fear. And unlike the conspiracy charge, this count focuses on the alleged conduct itself. Under federal law, the government must prove that property was obtained from another person, with that person's consent, but consent that was induced by force, violence, or fear. So the issue here is not just whether property changed hands, but how it was obtained, whether that consent was real or whether it was the product of coercion. This count also includes aiding and abetting, which means the government does not have to prove that every defendant personally carried out the extortion. Instead, they can argue that a person knowingly participated and intentionally helped bring it about. So the focus becomes what was obtained, how it was obtained, and who, if anyone, knowingly helped make it happen. Count 5 is interstate transport of stolen goods. This charge focuses on what the government alleges happened after the property was taken. Under federal law, the government must prove that goods were stolen, that they were transported across state lines, and that the person involved knew those goods were stolen. There is also a value threshold. The property must have a value of at least $5,000. So this count is not about force or restraint. It is about movement and knowledge. This charge also includes aiding and abetting, which means the government can argue that a person did not have to personally transport the property as long as they knowingly participated in or helped facilitate that transportation. So the key questions become, what was transported, where it was taken, and who, if anyone, knew the property was stolen and helped move it across state lines? One thing to watch in a case like this is whether the government seeks a superseding indictment. That would allow them to add additional charges, including potential firearm charges. And importantly, the government does not have to recover a firearm to bring those charges. They can rely on witness testimony, recordings, or other evidence to support an allegation that firearms were used or brandished. So even though no standalone firearm charges appear in the indictment right now, that does not necessarily mean they are off the table. It may simply mean the government has not brought them yet. If you are facing a federal investigation or federal charges, what you do early matters. For more analysis or to schedule a confidential consultation, visit the link in the description. If you found this breakdown helpful, like, comment, share, and subscribe to Inside Federal Defense. It helps make this kind of content more accessible and keeps it reaching the right audience.